use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So, as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident, and in misfortune, in doing any lawful act by lawful means, with usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. that is not the use of ordinary caution, and that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, and the killing is not done in a cruel and unusual manner. Well, this fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking, and we're all having fun, when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of second-degree murder. And the law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. And I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder.
Shallow.
For everything you've done to me.
Shallow.
For everything you've done to me.
Shallow.
Fuck you.
Shallow.
Fuck you.
Shallow.
Stupid.
Shallow.
That's my name. Don't wear it out.
Shallow. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do and choke me.
Shallow.
know from the evidence
You may continue.
Sarah. Sarah. Sarah, I can't breathe it.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or handsome. Now you want to give it for it extra. Because I got this.
Sarah.
Real or handsome.
Sarah. Sarah, I can't breathe it.
Oh. That's what I feel like when you jingle me.
Sarah.
Fuck you.
I can't breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13, 2020, approximately 1 month prior to George Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct, Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk, and this as well, about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it. Hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his... Judge, I object.
Approach. Objection overruled.
This is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on, meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Her being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismiss
this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it good.
I love you, baby. you understand. God will prevail and will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, they published from States 17, IMG 1063.
Sir.
It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, we see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. 2 people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Copsall and Detective Lowen, and more details come out. Things change. First, she was never intoxicated. Then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt. Well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt? A speculative? An imaginary? Or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching struggling for that way. That also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise.
State appearances for the record.
Dave Ketchner on behalf of the state. William J. for the Florida State Court. James Owens for Sarah Boone.
Captain Beck on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres' family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back.
Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. State appearances for the record.
Dave Ketchner on behalf of the state. William J. for the Florida State Court.
James Owens for Sarah Boone.
Captain Beck on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members of the jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Boone. And we feel confident that we're going to be able to show you why she's not guilty. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end, okay? And we're going to try our best to help you make the right decision, okay? But yeah, Milton's a small town.
Objection.
Overruled.
I'll tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando. Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach. Objections overruled.
all I wanted to say is just, since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. May we motion?
Yes. You may proceed. Objections overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force, but either way, however you rule, it still justifies her behavior, and the result is not good. Now, I don't believe there's anybody...
Objection, improper argument.
Overruled.
Objection to reproach.
Yes.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman, with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq. You know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you've got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time. Right? Time heals. Right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. I'm just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. She'd go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. I've got a bunch of notes. Something I wanted to read. Where did I put it? Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken. His actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma, that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out. You fall asleep, passes out. But it may turn by, depending on his mood. I don't know if you can tell. She would try to placate him. Dr. Brandon said, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. Essentially, okay, I don't know where it's at, but I'm going to have to come back to it. But essentially what it said was, eventually been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful and intoxicated and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you've got your buddies and the other guy's got their buddies and they're drinking and there ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Warner about this basal instinct, it's called fear response or fight or flight. You know, those decisions are made, it's instinctive. Based on your set of circumstances, she instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you remember, I'll go back to it. If you'll remember, that's what place it is. Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. No, it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe. I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
And I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote. Can't even find it. But it was something to the effect, maybe George Torres is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection, proper argument.
Sustained.
What has they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
And we'll get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew George Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it was called. And the state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach. You may proceed.
So for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with the Torah. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes. Remember those guys? And you remember it came out in the testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel, or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th. February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was. One of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe, I think we probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? You saw it. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen where she's telling him like it is. But she's got that video camera on and George knows. He's being videoed. We've got one that we will show you in a little bit. Where he loses it. Just a little bit. Right again. And of course we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response as a result of the abuse that she has suffered at the hands of George Thornton. She wants him, for that moment, to feel how she feels. She wants, for that moment, to feel. For him to feel how she feels. How uncomfortable. Lack of control that she feels when George is violent with her. Just for a moment, she wanted to feel that. And if you can imagine,
Approach.
I think from the evidence, you can determine she was crazy about it. She was crazy about that. And I don't know if, of course it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, then that's 9. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. It's all she knows, an old canvas. this suitcase that she's got some, the two zippers removed, or spread out a little bit so he can, so she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right? Well, especially somebody as hypervigilant as Sarah, and as hypervigilant as a battered spouse woman would realize, that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard. Trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining. And it's for support when you walk in it. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And, I want to talk about reasonable doubt for a minute. Can't find the page, but I've got a book. I've got a book here. Let me find it. If y'all are all looking. I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference. But 1 reasonable doubt about the state's case, and your verdict is not guilty, according to the law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. You know, reasonable doubt is the highest standard we recognize in litigation. You know, car wreck or something like that is preponderance of the evidence standard, 51%, you're entitled. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt. So I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we've recognized. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide that. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness. I want to show you this before I forget it. But Dr. Warner said, this is their expert again. He testified that Sarah Boone suffers from battered spouse syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres. Those past experiences with George Torres. And there's a bunch. Affect their perception. Remember Dr. Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase. She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I no more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody in court said, she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point she fell asleep. Passed out, fell asleep. We don't know. They had 2 big bottles of wine. Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? Do you remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, "Why? I was fighting back." You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? It's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in the suitcase. She panics. What does she do? What does she do? She tries to get her fiancé out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says, "She's come over." She calls again in 2 minutes. "I'm on the way." He gets there. You got to call 911. May have told her before, call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life. If she can. So the police get there. She knows if she told them, she fought back, she's going to be arrested. That's what happened before. What happened before, like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, who was the first short black female that came up here first, the first one that arrived with the body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, ma'am, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection. Facts on evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made those statements. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there were some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional. She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect that was going to happen? Now, I've got a daughter that she was about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. And eventually, it burnt the motor. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat-up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point, but I do want to show you. Just quickly show you the injuries. Sarah Boone got stabbed. Well, think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him. Poked between the eyes with a curtain rod. Stalked in the eye. I mean, who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did. I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways. I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first treated or first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with you. She talked about, that Sarah uses her words for power. I think her testimony, I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal opinion. Okay. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, that she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh. It's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome. That you stay trapped in it. I think another big, if you'll think about this. When Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence that she emotionally abused it.
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in the opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, and started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about...
Judge, name of the motion.
Yes.
Prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you in opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's that. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah Boone. Okay? Court system got involved. We would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. We know some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. The judge has been giving court orders all week. That didn't stop George Torres. George Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos, and then I want to say something to you. Shelby Andrews is going to help me. If we could dim the lights.
Yes.
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a room. I dare you.
Did you see him?
Yep, look at him. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it? Even though the video was going. Show the next one. Thank you. Thank you, Judge. You turn it off. Can you turn it off? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection. Improper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma that you're to utilize in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances in using the force that she used to defend herself. I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir. Any rebuttal?
Yes, sir.
You may proceed.
Ladies and gentlemen, George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well, or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, "Tag, you're it." Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. "Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owen, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping. And she ignored it. And she was kind enough to tell you why. Out of anger. Which translates to hatred, ill will, spite. Just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, "I can't breathe, babe," was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival. Him sticking his fingers out of the suitcase. Him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony, and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist, and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out, it's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such neighbor that the act itself indicates an indifference to human life. Well, I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiancée. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different. Tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were, and that she believed that he was cheating on them with her. And apparently she is too, with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, object.
Approach. May proceed. Objections overruled.
Let me say it loud and clear. Back spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase. After he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying. Did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres' head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back, are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him while he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Miss Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power, to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop, but she didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. Again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you. It's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both. Members of the jury, I have some additional instructions to read to you. If you would be so kind to turn to page 21 of 22. Instruction 3.12. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2000-CF-002603-0, State of Florida Plaintiff versus Sarah Boone Defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed, foreperson. The final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach. Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110. You've successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service. The rest of y'all, if I didn't call your badge, you need to hang out. Thank you. All may be seated. For you 6, you are that will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room. You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you. Deputy. You all can be seated. Thank you very much.
May I raise something real quickly? Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memories.
Any response, State?
That's not the law.
There's a verdict form, there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objection is overruled. Mr. J and or Mr. Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury? Yes, please. I'm going to go speak to the alternates and I'll return momentarily. Thank you.
Yes, please.
Okay. Does everybody understand that? I see everybody nodding their heads. Okay. State, are we ready to bring in our jury?
Yes, Your Honor.
Defense, are we ready to bring in our jury?
Yes, Judge.
All right, let's go ahead and bring in our jury. Everyone will remain seated.
You enter.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Yes.
If you could please hand the verdict form to the deputy, please. Thank you, sir. Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the 9th Judicial Circuit in Orange County, Florida, case number 2020-CF2603, the State of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together, and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, members of the jury, again, I thank you for your service. I'm going to ask you return to the deliberation room. I'll be back there shortly with your jury certificates, and thank you. Ms. Boone, the jury has spoken in this matter and has found you guilty of murder in the second degree. The court adjudicates you guilty of murder in the second degree. As this is your first felony conviction, you are entitled to a pre-sentencing investigation by the Department of Corrections. Mr. Owens, are you seeking that in this case?
Yes.
Okay. State, I will order the Department of Corrections to prepare the pre-sentencing investigation. State, for the purposes of sentencing, do you anticipate eliciting any testimony from, be it the victim's family?
2 or 3 victim impact statements, sir.
Okay. Mr. Owens, do you plan on presenting any evidence during the course of the sentencing hearing, sir?
Probably some testimony from Dr. Harper.
Okay. All right. How long do you think, State, that you would need?
You mean timing-wise, or are we thinking?
A quantum of time, sir. Yeah, well, normally it takes about 30 days or so. I'm confirming with Anita as to availability. I just want to know from your side of the ledger how much time. Okay, 15 minutes. How much time do you think you're going to need to produce anything from your side of the ledger, sir? Mr. Owens.
I'd say 30 minutes.
Okay.
30 to 45.
So if we set this for an hour, that would be sufficient.
Party agreed.
Okay.
State agrees.
Is that sufficient, Mr. Owens?
Yes.
Okay, all right, give me a moment. The court has had the opportunity to review the evidence and testimony that was presented at trial. The victim impact statements presented here today, the statements of character witnesses, both orally and in writing, Dr. Harper's report and testimony, the defendant's testimony, pre-sentencing investigation, the arguments of the state and the arguments of the defense. Court pronounces sentence as follows. Ms. Boone, court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily. There are also court costs and costs. Please.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
My name is Blanca Torres.
Okay. Ma'am, you can go ahead.
Okay, yeah. Okay. I just want to tell Sarah Boone that I don't hate her for what she did. And I always remember that evening when that lady came into my door and she knocked at the door. And she asked for my name. I said, I tell her my name. And then she said, can I come in? I said, okay, yes. And she told me to sit down. I never think that was going to be my son. And then she said my son was dead. Since that day, I can't sleep. It's hard for me to remember that moment. My son is not here no more. She don't only kill my son, she killed a father, a brother, an uncle. It's been hard. And my family, because all the brothers, they will always work together. But now it's like something real. Love is missing. Sometimes when I look out the window, I'm waiting for him to come and say, Mom, I love you. She was always there. She called me. I miss that mommy. The last time that I talked to him was at 12 o'clock in January, New Year. He came to my bed and said, Mom. He woke me up and I said, Mom, I love you. Happy New Year. Since that day, I don't see him no more. It was my son. I love him. And I miss him a lot. My family miss him a lot too. But I don't hear her. But you know what? I was blessed. She ain't gonna be blessed like me because I have my son. I raise him. I have his children, my granddaughter, my grandson, and she don't gonna be able to have that. And I did. I raised him. He wasn't perfect, but he was a good son. Thank you.
Thank you, ma'am. State anything further from this witness?
No, Your Honor.
Defense?
No, sir.
Thank you. You may call your next victim impact statement.
Victoria Torres.
Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ma'am, could you state and spell your name for the record for us, please?
Victoria Torres. My name is Victoria Torres. George is my brother. Unfortunately, my family has experienced two horrifying tragedies. I just want to make it clear that George deserves justice. As far as my other brother and Sarah deserve to rot in jail. Sarah has caused a lifetime of pain, a lifetime of horrible images, a lifetime of hearing my brother George plead for his life. This is just this moment for all of you. For me and my family, it's forever. Such a simple thing as using a suitcase is so triggering. I try not to close it all the way. I leave at least like 2 or 3 inches for the zipper. And it might sound crazy, but it just helps me. She really has flipped my family's life upside down. And I just hope that we can truly get justice for my brother. And I just want to tell the team thank you so much for everything they did. Thank you.
Thank you. State anything further?
No, Your Honor.
Defense?
No, sir.
Thank you.
Your Honor, could we see if Ms. Anna Torres is...
Okay. Okay. So I'll be speaking for myself and my two siblings. The murder of our father has impacted us on so many levels and in different ways. I myself, for the first year, would wake up screaming every morning or night, wishing I was having a nightmare, only to wake up to remember all over again that my father is gone and I'll never be able to hear him say he loves me ever again. To know my siblings have been affected in such a way that they are now different. They have had a piece of their heart ripped away from them, all while her son gets to hear his mother's voice and see her alive is pathetic. Because of you, Sarah, my sister is heartbroken. Because of you, Sarah, my brother is left wondering when he will ever see his father again. The loss of my father has left me with chronic depression and anxiety. Seeing any moments of fatherly love or kindness being shown between others in real life or even on TV leaves me in complete shambles. Seeking therapy was a must in order to navigate through my workday without a random breakdown. Thoughts of my father's demise still enter my mind ever so often. I'm left either angry, sad, or sick to my stomach to think of how his final moments were. George Torres, my incredible father. Not only was he my father, but my best friend. My personal comic provided me with wisdom and knowledge, creative and loving dad, an older brother, an uncle, a cousin, a friend, a son, and above all, our father. He was human and deserved to be treated as such. My father, George Torres, was one of a kind, an absolute gem. Unfortunately, his light was dimmed on earth by evilness, but with us, we will forever make his name live on. Especially Sarah. I pray that you see his face when you see him at night. That is it.
Thank you. Anything further, State?
No, Your Honor.
Anything further of this witness?
No, sir.
All right, thank you, ma'am. State,
Thank you.
Anything further?
No other impact statements, Your Honor.
Thank you. Any other witnesses or evidence at this point in time, State?
No, Your Honor.
All right, Mr. Owens, you may proceed, sir.
Ms. Diane Smith. Judge, what do you want?
I have no issue with her being at the podium. If you want to move about the well to conduct your examination, that's fine, Counselor. Ma'am, come on up. Coming up to this podium right here, ma'am, if you could, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, could you state and spell your name for the record for us, please?
Diane Smith, D-I-A-N-E-S-M-I-T-H.
Okay, thank you very much. Counselor, you may inquire.
And Ms. Smith, tell the court a little bit about you.
I was a chaplain at the 33rd Street Jail for 30 years.
And have you been a chaplain at the jail here in Orange County?
Yes, Orange County Jail
Is it the same
for
jail
30
you're
years.
referring to? Okay. And during that period of time, did you have occasion to meet with Sarah Boone?
I did.
And was it over the course of how long?
I've known her 4 years.
And if you could, tell the court what you'd like to say.
Okay. Well, I first met Sarah. She came in. We have a Christian dorm, and Sarah enrolled in our Christian program. And she was in my classes for a year. And she was very sincere in her efforts to change her life and to be a better person. And I found her very helpful. She was kind and good to people. She loved to serve. And she helped the new girls that would come in, the younger girls. She would mother them and be very kind and very helpful. And then after she graduated from the program, I was her counselor for the other 3 years. And I always found her, very sincere and, trying to do better. I spoke with many inmates that knew her and was associated with her. And they spoke very highly of her and said that, she was helpful and kind and tried to help other people. And I just found her to be, very sincere and trying to be a very good person and change and help people.
Was the Bible involved at all?
Oh, yes, it was all spiritual. Yes, it was spiritual growth plus character, growth and character, trying to just be a better person in general. She liked to serve other people, she would help the girls wash their clothes and show them around and teach. But spiritually, she grew very, very great spiritually.
Thank you.
Hang on, ma'am, just one second.
Ma'am?
Hang on just one second, Ms. Smith. State, any questions?
No, Your Honor.
All right, thank you, ma'am, I appreciate you.
I'd like to call Christina Pena. This right here.
Yeah, it's fine, Counselor, thank you. Ma'am, come on up if you can. Raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Ma'am, if you could state and spell your name for the record for us.
Christina Pena, Christina
All right, you may inquire, sir.
Ms. Pena, how old are you?
31,
And where do you live?
in Orlando.
Now, it's my understanding, Ms. Pena, that you were in the county jail with Sarah Boone.
Yes.
How long were y'all in the same cell together?
Yes, I was in there for 4 years, but we were together for 3.
Okay. And I understand ultimately the charges against you were dismissed?
Yeah.
And so you were released on what then?
April 4th this year.
2024?
2023.
2023. So you've been out for a pretty while.
I've been out for like 6 or so months now. Yeah, since April
Okay.
of this year, actually. Sorry.
April of 2024. And you said y'all were bunkmates there together for about 3 years?
Yeah.
I would assume that y'all got to know each other pretty well.
We did.
Okay. And if you could, if you'd like to speak on her behalf to the judge.
Yes. Sarah's one of my best friends, my only.
Take your time.
She's helped me with a lot. Spiritually and like growing and she helps everybody. She's always, I don't know, she helped me a lot, and she would come to me, she'd talk to me all the time and pick me up when I was down, or if I didn't know something, she's good. I don't know, she was a good person to me. Mistakes happen. She always helped people. She was always helping everybody in the dorm. Even like her artwork, she did art. If anybody needed any help or needed anything, they'd come to her and she'd help them. And even if they, did wrong to her, she would still go back and help them and praise with them and pray over them and everything. It's just.
And was she a little bit older than you?
Yeah.
How much older was she?
40 in her 40s.
Did you think of her as maybe an aunt or a big sister?
Big sister, yeah. She was like a big sister. Like a sister I never had. Because I have brothers, so I never, we clicked right away. I don't know. We'd be walking out in the backyard and she just would always try and talk to me, but I'm a quiet person. I don't trust a lot of people. So for me to open up and trust somebody, it's a lot. So.
And obviously y'all were there under difficult circumstances. Did she assist you in getting through that?
Yes, and she helped me a lot with my case, and I would help her with hers too. We're both. Justice is not what it is. I don't know how.
Bless you.
We both helped each other out. I don't know.
Ms. Pena, I appreciate it. Thank you.
Any questions, State?
No, Your Honor.
All right, thank you, ma'am. I appreciate you.
Ms. Hill? Judge?
Yes, sir.
After Ms. Hill, I want to take Ms. Howard.
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
My name is Mariela Hill, Mariela, last name Hill, Hill.
Thank you. You may proceed, sir.
Ms. Hill, briefly tell us a little bit about yourself.
I met Sarah in jail. I spent 3 months in jail and went through a lot of unfortunate circumstances myself.
All right, now this was in the Orange County Jail here in Orlando?
Orange County Jail.
And
correct.
when would that have been? Do you recall the dates?
Yes, it was April, from April to June of this year.
Of this year,
2024.
2024.
Correct. Yes.
Okay. And did you develop a relationship with Sarah Boone over the course of that 3 months?
Yes, yes. We met when I was moved to the B dorm, and I needed help with a form that I needed to complete, and one of the COs pointed to Sarah to help me out. And since that moment, we became really good friends, and she was so helpful, so kind, so respectful and loving, not just to me, but to everyone. And I have nothing but good things to say about her character, her loving heart, and how deep her faith is, her faith in God and believing in justice for everyone. So that's what I believe.
State any questions?
No, Your Honor.
All right, thank you, Ms. Hill. I appreciate it. Ms. Albert, good afternoon, ma'am. Can you hear me? This is Judge Kranick, and if you can, I would ask you to turn on your camera and unmute yourself at this time, please.
Sir, how do I unmute turn on my camera? I know how to unmute, but I'm not sure how to turn the camera on.
Turn the volume down.
So, ma'am,
Is that better?
When you join the link, there should have been an option for like a pull down on the left-hand side of the screen for you to open out or turn on a camera. I don't know what device you're appearing on, if it's a cell phone or a laptop.
It is an iPhone. Should I try to re-enter the room?
Yeah, try to do that. There should be an option for you to pick a camera. And you'll either select the default camera, and hopefully we'll be able to see you at that time.
Okay, let me, just give me 1 second.
Sure.
Did that work? Can you see me?
I cannot.
Shoot. Yeah, it's saying default camera. It's saying front camera. I chose it. It didn't show my face or anything like that.
My technological skills are limited. State?
I have no objection to the witness making their statement here telephonically.
Okay, appreciate it. All right, Miss Albert, good afternoon. If you could just state and spell your name for the record for us, please.
Certainly. Lana, L-A-N-A, Albert, A-L-B-E-R-T.
Okay. All right, Mr. Owens is going to ask you some questions. And if you could just answer them, ma'am, I would greatly appreciate it. Sir, you can proceed.
Miss Albert, do you have the ability to turn your volume down?
Yes, I just did. I can't hear you very well when I do that, though.
You can't hear me?
I can hear you, but very, very quietly.
How about now?
Yes, I can hear you. Am I okay?
Yeah, you sound a lot better. You were too loud earlier.
Okay.
Can you hear me okay?
I can hear you.
All right, Miss Albert, tell the court a little bit about yourself briefly.
Well, I live in Minnesota. I currently have end-stage renal disease. Before I became disabled, I was a business owner in the Twin Cities here.
All right, and how old are you?
I am 50 years old.
All right. And you're considered disabled?
Yes, I am.
All right. And have you had an occasion since this event to establish a relationship with Sarah Boone?
Yes, I have. We have been friends for the past a little over 11 months.
And how do y'all communicate?
We've communicated a lot of phone calls, lots of tablet back and forth, and a lot of letters as well. I'd say many hours of time spent with each other.
All right. And do you want to speak on her behalf here today?
I would, please.
All right. Would you please tell the court what you would like for the court to know?
Thank you very much. And thank you very much, Your Honor, for the privilege of speaking on behalf of my friend Sarah Boone. I also want to extend my heartfelt condolences to everyone here affected by this terrible tragedy, which has brought us all here and listening in. Many articles and videos and opinions of Sarah have gone out in the airways and on the webs. Opinions that have been formed and commented on so much that it's hard not to give into the temptation to treat people like a comic book or a fictional character. In the case of my friend Sarah, the words narcissist, Karen, villain, many other things, they roll off the tongue with little regard to the humanity that is dismissed so flippantly. And under a lot of circumstances, I was one of those people, as I have a love of true crime. And becoming friends with Sarah has shown me that there's a lot more depth to the people I see on the screen. I'd like to share with the world and with the court about the Sarah Boone that I know. Sarah Boone is a kind, honest, and good person. The Sarah Boone I know is one who loves animals, especially the kind who are damaged and defenseless. How many of us would take in and pour love for a hearing impaired and a sight impaired pair of dogs? She has a natural instinct to help reach out and give of herself, her time and energy and love, especially to those who are hurting or damaged. You all have seen her fight for her own life and truth here. I tell you this, she fights even harder for those she loves, giving time, attention, and companionship without a single thought for her own gain or what somebody can do for her. And one huge example is in the matter of our friendship. As I said before, I have end-stage renal disease caused by a genetic illness called polycystic kidney disease. As my life has progressed, things I have taken for granted have been taken away from me. I could not appear in court in person because I can no longer walk, as my dialysis treatments have affected the circulation of my legs and has confined me to a wheelchair. To say that my life has radically changed is an understatement. Through it all, I have many friends and family I love and cherish. Sarah has distinguished herself differently in this way. In the course of getting to know her, I started sharing the progressing state of my health. It was like lightning had struck her. The moment Sarah had learned the depth of my struggles health-wise, she straight up offered strenuously to donate a kidney to me. I got to tell you this. I hope she's not mad for me showing this, but she had no hesitation, no concern over personal risk or personal gain. I want to convey to this, out and around the world, that is merely offering is a good and heroic act. I've had many friends. I've not had one outside of my brother who has offered me a kidney. That is huge. I don't have anything of equal value to give to her. And that's not the actions of a narcissist. She did it as a reflex action, as a good person. After the verdict came in October, we spoke that night. And I hope Sarah doesn't get mad at me again for disclosing this, but out of all the shock and seriousness of what had happened in the court, the thing that made her emotionally break was that she realized she could no longer be a donor to me. I mean, I was sitting there like, hey, you know, it's going to be okay. But she was so broken up, she couldn't help me. That's a friend. She is not, nor does she come up anywhere remotely close to being a narcissist. Now, one more thing before I go. Social media has worked to rip the blindfold off of Lady Justice, to take the sword out of her right hand and start assassinating Sarah's character. However, the scales are the balance. As it says in Psalm 85, mercy and truth are met together. Righteousness and peace have kissed each other. Justice isn't justice without mercy. Our pursuit of righteousness isn't complete and right without peace. Thank you, Your Honor, for the honor of speaking for my friend Sarah Boone. I hope that your justice is mixed with mercy here today. Thank you.
State, any questions?
No, Your Honor.
Any follow-up, Mr. Owens?
No, Judge.
All right. Thank you, Ms. Albert. I appreciate you.
I'd like to call Dr. Harper. You want her on the stand or?
I'm okay with her on the stand.
On the stand?
No, she can be right now. Yes, sir.
Yes, sir.
I want to see Kevin.
Judge, you want her on the podium?
No, she can be at the podium. That's fine. Doctor, good afternoon. If you could please raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do.
If you could, Doctor, state and spell your name for the record for us, please.
Dr. Jolee Harper, Julieharper.
All right, thank you. Counselor, you may inquire.
And Dr. Harper, we all know we were here a few weeks back for the trial, and your testimony said the judge knows quite a bit about your testimony. But if you could, I know that you prepared a report, and we have submitted that to the court, which the court has read, and the state has a copy. And I don't know if you want to refer to that or just speak on your own about Sarah Boone and what you did to assess her, and then any opinions that you want to express.
All right. I think that during trial testimony, I reviewed all of the documents, excuse me, and all of the records that were available. They're documented in my report as well. In addition to the forensic clinical interviews that I conducted, I also have had the opportunity to talk to her brother, Philip Paulson, in the interim since the trial, and I included his information in my report as to her family background.
If you could, give the court a synopsis of what your findings are, and what you uncovered maybe from the brother, whatever you think the court needs to hear this relevant material to his decision in this case.
So referring to the summary section of my report, I'll keep it a brief, but I'll outline the highlights that I feel like haven't been conveyed before, which is an understanding of Ms. Boone's early family life, in that she is the middle child of her parents' union, and that her parents did not have a happy marriage. They didn't provide an opportunity to have a good role model as to how to have a partnership together. Ms. Boone was born in close proximity to her youngest brother, 11 months apart, and in my clinical experience and training, I would say that that disrupted her attachment with her mother, some being close in proximity with her younger brother, whose temperament just seemed to suit a relationship with her mother better than her own. So ultimately, Ms. Boone bonded with her father, though he wasn't described by either child as an affectionate person. He was somebody that was there for her at sporting events and more of a primary parent for her in that way. His untimely death by heart attack during her high school years was marked by her brother as a turning point for her in how she was acting at home. Her demeanor, her relationship with her mother took a turn for the worse as she was not coping well. She was using substances based on what her brother was saying. And it is my opinion that that early lack of foundational relations with her mom and not feeling very secure, the death of her father, destabilized her. That's a period of your life when you're leaving high school, when you should have formed a very solid foundation to go out in the world. And I don't think that that's what she had at that moment. She bonded easily with Mr. Boone, and you can see that there are elements of that early difficulty with her relationships because she took on a parentified role, in my opinion, during that relationship. And therefore, there's a power imbalance in that she was making decisions and not, again, having an equal relationship. I think that that led her to a sense of being a need to be right, a need to feel like she is the one that's making good decisions, to have some ego support by being in the right all the time with Mr. Boone. And I think that that led to some behaviors that she carried over into her relationship with Mr. Torres, in that she's parentified around him and acting more like a parent-child relationship, being a facilitator of housing and applications for jobs and things like that. So again, there's a power imbalance that I think was very seriously misaligned, as her brother and the property manager of their apartment had verified. They saw her being abused, physically abused in serious ways, or the effects of the abuse in bruising or calls to them. It is my opinion that she called for help, but when people got tired of her not leaving Mr. Torres, they stopped responding to those calls. And basically, Ms. Boone handled things on her own. And as other people with healthier boundaries probably would have left, she, being acting out the pattern of intimate partner violence, did not leave. She stayed long past when it would have been smart for others, or others would have said to leave. Sorry. The undergirding of that not leaving the relationship is a long-term anxiety problem that became post-traumatic stress disorder. There is an earlier instance of exposure to traumatic stress in that she was the person in the hospital after her father died who found him having students perform CPR on his dead body. So that was an early exposure to high traumatic stress, witnessing that incident, and based on her brother's description, that was something that changed her. When a person is exposed to numerous compounding stressors, their adrenaline system is changed. It alters your body. And things that might be an otherwise neutral situation, you tend to have a cascading adrenaline response to that. And I think that that ultimately, for her, as she succumbed to other instances of serious physical abuse from her partner, became post-traumatic stress disorder. I do think that that is a condition that is still existent even while she's in jail. It's something that she needs treatment for because those triggers are unmitigated, meaning that she hasn't really had the kind of therapy to address them and reduce her adrenaline and anxiety responses when she thinks of past instances of traumatic events that have happened to her. You can also respond to post-traumatic stress disorder clinically by using antidepressant therapy, and that would be something that could assist her ultimately in reducing symptoms if she had counseling and antidepressant therapy.
Now, Dr. Harper, I know you had testified at the trial that, in your opinion, she suffered as a battered spouse, the syndrome that is legally recognized in Florida, in the courts of Florida.
That's correct.
And I understand that that is tied to this intimate partner violence, which is maybe the same thing, but there's a complex mental health issue that ties into that. Can you speak on the complexity of that whole cycle that one such as Sarah Boone and George Torres were involved in?
Certainly. So intimate partner violence is not a diagnosis. It's a pattern of events that occur between two partners in which the power dynamic is altered by the physical abuse or behaviors that are controlling in nature to the point that someone's safety is threatened. It's common for victims of that to have a complex mental health condition, often including depression, anxiety, and substance abuse problems. And what might be substance abuse to cope with the problem, like numbing oneself, will sometimes result in its own diagnosis. The pattern of intimate partner violence, I think we covered in the trial, but just in summary about that, there are phases in which at first the bonding of the two partners might be something positive. They've got something in common or have pleasurable time together. And then the secondary phase of that is when there is change in dynamic and some kind of traumatic event occurs, some instance of physical violence. And then there's a third phase in which it's like a honeymoon phase where they're trying to right the relationship. So in phase 1, when they're having something pleasurable, the tone shifts. Phase 2, there is some kind of incident. And phase 3, there's a honeymoon phase. As that pertains to anxiety, I think that a person who suffers from intimate partner violence never stops experiencing that hypervigilance, waiting for the next instance of violence to occur. So even though they may look happy, they might be experiencing something positive, they've not really relaxed because their memory that could or will occur again is still in their mind. So they haven't fully stopped experiencing intimate partner violence. It's just what phase of the process they're in.
No, and Dr. Harper, it goes into more detail in your report, which I supplied to the court, which is a total of 11 pages, and I believe that's confidential document.
That's what's been marked. I don't believe it's been filed in the court file.
Okay.
If it has, that's something if it needs to be, it's something we can address. I have reviewed it. It does reflect confidential and privileged information on the first page. I don't believe it's been filed in the court file unless you did it. Okay. It already has been? All right, appreciate it.
Under seal.
Okay, excellent. Thank you, sir.
And Dr. Harper, you're aware that the defense has filed a defendant's motion for downward departure.
Yes.
And we've listed several factors under paragraph 3, the capacity of the defendant to appreciate the criminal nature of her actions and conform with the requirements of law or substantially impaired, that she requires specialized treatment for a mental disorder that is not related to substance use or addiction, although you agree that she does suffer from alcohol use disorder.
So she has an underlying mental health disorder, post-traumatic stress disorder, and I additionally diagnosed her with alcohol use disorder, which is separate.
But you agree she does require specialized treatment for a mental disorder that's not related to the substance abuse or addiction?
That's correct.
And you agree she's amenable for treatment?
Yes.
And you would agree that she acted under extreme duress in this unique homicide case?
Yes.
And you would agree that the uniqueness of the circumstances, the facts and circumstances surrounding the case, that the offense was committed in an unsophisticated manner?
Yes.
It was isolated.
That's my understanding as well.
Other than she had the charge, which both of them were charged at one time, and I think she had the strangulation allegation, the felony case that was ultimately dismissed when both of them were arrested.
She had a prior felony case. Facts are different, of course, than this particular case we're related today.
Dr. Harper, I believe that's all the questions I've got, unless you would like to say, if I've missed anything, of course.
No, I think.
Okay, and if not, it's in the report.
Yes.
Any questions?
Yes. May she take the stand so I can take the podium?
Yes, that's fine. You may inquire, sir.
In pages 1 and 2 of your report, you go through the sources of your information, correct?
Yes.
And that would include 8 interviews that you had with her from the course of August of 2020 through September of 2024, correct?
There were 9 interviews, but 8 dates of service are listed.
You did the Miller Forensic Assessment of Symptoms Test, or MFAST.
That's right.
Inventory of Legal Knowledge, ILK.
That's right.
Clinician-administered PTSD Scale 5 examination.
Yes.
You consulted with her attorney.
Yes.
Videotaped interviews from this court case number of Sarah Boone, interview part 1 and 2, Abraham Moreno interview, Brandon Motes interview, Brian Boone interview, Juan Torres interview, and Melissa Sexton interview, correct?
Yes.
You reviewed the autopsy photos?
Yes.
You reviewed some of the digital forensic exhibits, including the Apple iPhone XS and a Samsung SMJ 327 T1 photographs from those 2 devices?
Yes.
You reviewed Bates stamped discovery pages 1 through 413.
That's correct.
The crime scene photos are photos of a scene taken on June 19th of 2020.
Yes.
Aspire Health records.
Yes.
And who do those pertain to?
Aspire Health records are for Sarah Boone.
Florida Hospital Medical Group records.
Yes.
And who do those records pertain to?
That is also for Sarah Boone.
And Aspire, is that a mental health treatment facility?
It has an emergency department record, but that would be the place where she was detained under the Baker Act.
And it is routine and common in the practice of forensic psychology or psychiatry to rely on the records of other such practitioners.
As a source of information, sure.
You reviewed the deposition of Dr. Tanya Warner.
I did.
You reviewed the trial testimony of Sarah Boone, Brian Boone, Dr. Michael Brannon, Dr. Tanya Werner, correct?
Yes.
The jury verdict form dated 10/25/24.
Yes.
Witness list notice of filing amended
Yes.
on this case. Records of Jorge Torres or George Torres involving case numbers 2019 MM 5114, a 911 call and PDF, case 2019 MM 7193, case 2019 MM 7193, Torres Public Records, case 2019 MM 7193, Torres Photos, Central Florida Primary Care Records, Advent Health Orlando Medical Records, correct?
Yes.
And those latter records that I just mentioned, those for Mr. Torres and not Ms. Boone, correct?
That's right.
Then you reviewed Sarah Boone written correspondence, Sarah's listing of domestic violence incidents, Sarah's writings regarding missing days of work and Baker Act, and a 74-page life story.
That's right.
And then case 2018 CF 10573, public records and photos.
Yes.
And a telephone interview with Melissa Sexton, the property manager, which you conducted on October 1st, 2024.
Yes.
And a telephonic interview with Philip Paulson, the defendant's brother, on November 26, 2024.
Yes.
Where has Ms. Boone been housed and living since February of 2020?
At the Orange County Jail.
And does the Orange County Jail provide mental health services to inmates?
It does.
And you already testified you would routinely, as a forensic psychologist, review records kept of a psychological or psychiatric treatment of a patient or a client, correct?
Yes.
In this particular case, have you reviewed any mental health records generated by the Orange County Jail for Ms. Boone?
No, I have not had the opportunity to do that.
So, for the last 58 months or so, if she was being seen by the mental health treatment staff at the jail, you have not reviewed those records?
That's correct.
And they are overseen at the jail, in the Orange County Jail, by a psychiatrist. Are you aware or not?
If the person's level of mental health intervention deems them eligible for psychiatry, then they will.
And any diagnosis or lack of diagnosis that they have had during the course of the last 58 months, you are unaware of because you did not review the records?
That's right.
I don't have any other questions.
Any redirect examination?
No, Judge.
All right, thank you.
One question. Dr. Harper, I didn't ask you to review those records, did I?
No.
Thank you.
Judge, I believe you said it at the very beginning that I had submitted several letters on behalf of Ms. Boone, and she didn't hear that, but I wanted her to be made aware.
Yes, ma'am.
And you don't actually read those letters into the record, but you did read them.
I have reviewed them. They're in my binder here. How many do I have? Yes. Give me a second, I can tell you. I have I have 6 handwritten letters. First one is 1 page. Second one is 2 pages. Third one is 1 page. Fourth one is 2 pages. Fifth one is 2 pages. Sixth one is 2 pages. I have a typed letter from Diane Smith, the assistant chaplain. I have another typed letter from a Nicole Ray, a typed letter from a Stephanie L., a typed letter from Philip Paulson, an email from Lana Albert, 2 pages in length, and a 2-page email from a Danielle Parsons.
Thank you.
Yes, sir.
Judge, I would like to call Sarah Boone.
You may proceed.
If you could take this.
Yes, please. Ms. Boone, you can be seated. You've been previously sworn. You may inquire, sir.
For the record, just state your name again.
Sarah Boone.
All right. Now, this is unlike a trial, so you're allowed to speak in a narrative form, as well as I understand you have taken some notes or written a letter that you want to read from, and then you want to speak to the court after that.
Yes.
All right. Why don't you go ahead and get started?
This is actually an edited version of.
Hold on a second.
I had a lot to say. I've had a lot of time to think about things, and I didn't really know how to put it on paper, and I didn't know how much I could say or how little I should say. So what I have here is, like I said, an edited version. But I would like to read the more important parts that I feel that everyone should know that wasn't said in my actual trial. And on top of what I have on paper, this is just the tip of the tip of the tip of the iceberg. So I wanted to read this, and then, if I may, I would like to address everyone in my apology on top of my statement.
You may proceed, ma'am.
Kintu Sukuroi is a kind of Japanese ceramic style which means to repair with gold. In this tradition, when a ceramic piece breaks, an artisan will fuse the pieces back together again using liquid gold or gold dust lacquer. So rather than being covered up, the breaks become more obvious and a brilliant new piece of art emerges from the brokenness. It embraces flaws, weakness, and imperfections, and also teaches the essence of resilience. Every crack in a ceramic piece is a part of its history, and each piece becomes more beautiful because it has been broken. This is the wisdom of Kintu Sukuroi. In my wisdom, and with all of my repairs, then, now, and ongoing, God is, has been, and will always be my artisan. All of my gold is forgiveness. This has held me together, made me shine brighter, and overcome the damage caused by George Torres, the Torres family, the justice system, Orange County Corrections Department, social media, scoundrel detectives, infamy, defamation, ongoing constitutional rights violations, second-degree murder, forced into being pro se. Just as gold is very precious, forgiveness is invaluable. Forgiveness is not an attempt to change or forget who, what, or how you've lived through to be so gold, but an act of grace, humility, and considerable self-compassion to be set free from sorrow. Withholding forgiveness denies your brilliance and adds even greater grief and deeper heartache, irreparable cracks on top of the already that no one deserves, no matter the pain or disappointment, untruths or injustice. It doesn't matter. As the more broken you are, even though now different than before, you've become more outstanding and more extraordinary. Above all, when you let go of blame, misunderstandings, excuses, give up your anger and cease from resentment, this is forgiven. And when you forgive, you heal. And when you heal, you move forward. My goal begins with George Torres, and every time he slapped me, kicked, punched, spit on, raped, stabbed,
choked, laughed at, pushed, pulled, dragged, whipped, tripped, stole from, lied, terrorized, threatened, humiliated, forced, degraded, made me cry. Every time he tried to end me, defeat, or destroy. I forgive George for beating me senseless, for trying to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions, and keepsakes, my son's furniture, destroying the television we watched together, for wrecking our townhome by breaking windows, punching holes in the walls and doors, ramming his entire body into glass doors, kicking in my front and back door over and over and over, for breaking or removing the locks from all of the doors and sometimes the knobs altogether, so I had nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed. For terrorizing and threatening my blind and deaf dogs by leaving the gate open I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond or scrape their remains off of the pavement, for kicking them off of the bed and throwing across the room because they were trying to protect me, for threatening to make me unrecognizable to my son by breaking all of the bones in my face, like his brother Moses did to him after he kept seeing all of the bruises from George beating me, like all of the times their father beat their mother, for all of the drunken rages and fist fights with so many neighbors when wandering into their apartments during hunting expeditions after I had escaped, for drowning me in liquor and wine because I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face, giving me 2 black eyes and a bloody nose, for making me experience what it is to be sodomized, threatening to kill my friends and the neighbors when they checked on me to make sure I was alive and in one piece, for threatening to burn down our townhome and set my car on fire because I got a job, for holding me hostage on weekends my son was supposed to come over by keeping my keys around his neck, my phone in his crotch, and a butcher knife stuck in the middle of the table as a warning not to ask anything or try to leave, for stabbing me in the leg and not letting me call 911 for an ambulance or seek help, where I nearly bled to death until I concocted a lie to save him from being arrested, for destroying my phone with a hammer because my son called, for me experiencing ever being arrested and after today, prison, for beating me almost blind, crushing my occipital lobe, for having me experience what it means to see stars like in the cartoons where a character has a tall lump on their head. I had that too, and many times, for dragging me downstairs by my hair in the middle of the night just to sit next to him, for taking my car driving drunk with my debit card to buy more alcohol while I slept, even after I kindly explained the importance of my car to take my son to school foremost, me to work, and he to his batterers intervention classes and probation officer meetings, where I would be forced to sit for hours in the parking lot waiting for him, for causing me so much trauma and pain mentally, physically, emotionally. I had to be hospitalized more than once, for destroying my reputation and integrity, for my M for murderer scarlet letter, not letting me feel safe to live, talk to other people, spend time with my son, have a job, friendships, simply go to the bathroom with the door closed, or go to sleep soundly or comfortably. I forgive George for lying, for him trying in so many ways, so many times, to end me with his terrifying love. I also forgive the Torres family, his mother and father foremost, also his 2 ex-wives and daughters, all for knowing who George was, capable of, and has done in the past, his history of violence and where he learned it, then to keep turning a blind eye when I would ask for help. All of his siblings, including Farrell Torres, who is now on his way to prison for stabbing the mother of their baby in the side of her head. For everyone who knew what George was doing to me, sometimes how and when, but allowed and enabled. I forgive them for caring too late. I hope they all ask themselves while quiet and comfortable in bed at night the uneasy question, what could I have done to stop this from happening to both of them? And after all the times Sarah tried to, by asking for help from all of us and so many times. Another great contributor of my gold is social media, with its greed, insensitivity, deception, obvious exploitation, and advantageous gain from my criminal case as a whole, and for sentencing me by anticipation as a result of ignorance and hate, conjured and fabricated by the organized crime that is social media, which condemned me in the court of global public opinion since the beginning. My family law case is the new prey waiting to be picked apart and pillaged from me being made infamous by social media in my criminal case. It simply seems I cannot forgive and be forgiven and move forward. Social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. In my criminal case, as a result, my opportunities to be given a fair, proper, and uninfluenced, successful conclusion was heavily depleted and poisoned. I forgive them. Also, all of the media tycoons for not having a life of their own, trying so desperately to make themselves seem so right by making me appear so wrong. Forgiveness for prejudgment, ridiculous theatrics, lies, making and taking blood money from my and others' misfortunes, accidents, and catastrophes. It's all over their hands and their keyboards. And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed, in my case, still no one knows me. In the end, I forgive myself for not choosing my life sooner, for not being more brave, vigilant, bolder, and outspoken, stronger, mentally, physically, emotionally, and spiritually, for being hopeless, desperate, simple-minded, weak, and inexperienced. I forgive myself for not realizing I was enduring a life of domestic violence and that the vicious cycle of never ends. I had nothing to compare to. I've never been hit by a man ever before in my life. I was raised hitting a woman was wrong and should never happen. No excuse. I forgive myself for not escaping permanently, for not fighting back sooner to save myself, my son, my dogs, home, and car. Having 20/20 hindsight thinking of everything I could have done differently or better to avoid the outcome. I think about this every day since. Also, of all the good days we had together, for him at least, while I was constantly in hyperdrive, high alert, and paranoid, making sure I did everything right all the time. If not, the great possibility I would be ended as George threatened me with so many times before. I forgive myself for falling in love with a monster, and no matter how grotesque he may become, I still loved him, hoped, and forgave. I tried breaking the spell so he wouldn't be a monster anymore. I saw who he was inside. George made me then, now, and always love him for all of his cracks also. We made each other our own brilliant pieces of art from the cracks and repairs. Unfortunately, not all cracks can be. In all of my forgiveness, George is my greatest lesson and will forever be a part of me. I think of him every day and still speak to him when alone on the rec yard. I ask his forgiveness and that he looks for me at the gates of heaven so I can tell him how sorry I am, endlessly, and that I never stopped loving him. In all of it and still. When I first came to jail, I put my mat under my bed and cried all day and all night for months, only falling asleep from being so exhausted with grief. I wrote him letters. I wrote his family and his daughters, apologizing for asking for their forgiveness. But due to fear that my life or sons would be jeopardized, I did not send. I am sorry. I cannot begin to fathom any of their grief and sadness. Please forgive me. Almost everything reminds me of him, seeing my stab wound especially every day especially. It truly reminds me that all I really did live through. George haunts me. He is everywhere. I believe because I do still love him, think of him, and miss his laugh the most. In my heart, I know he is with me and understands that this tragedy was not intentional. I hope everyone can, his family foremost. I didn't mean for this to happen. Please wholeheartedly know that, and always, I would never. Forgive me, George. Forgive me, Torres family. Forgive me, Judge Cranick. To the entire planet, please forgive me. I graciously and humbly ask for consideration, for forgiveness to be extended instead of judgment, for reconciliation and restoration for all of us to move forward. My apology is profuse and ceaseless. Allow me, please, to brush off the muck, wipe the blood off of my face, and fix the cuts in my skin. I ask for understanding in what really happened and for how long, for second chances, repentance, and redemption, to advocate for all domestic violence survivors, to help them overcome, heal, and still hope, always, to make their voices heard, to confidently walk with all of their scars on the outside and the inside, to help them not ever become a casualty of domestic violence as so many others, to stop the abuse and maltreatment before it's too late. There is always hope, and you can survive. In my soft-spoken conclusion, I ask this: would I be the darling mother, celebrated woman of the year, if it were I who died? How many daughters, mothers, sisters, aunts, grandmothers, nieces, and friends have been because they did? I am a survivor. Learn to do good, seek justice, rebuke oppressors, defend the fatherless, plead for the widow. Isaiah 1:17, all-encompassing, protect the abused.
Ms. Boone, is that the end of your written statement?
Yes.
Now, gathering your thoughts, did you want to make an oral statement?
I do.
All right, would you do that now?
Yes, please. My statement, my verbal statement, is primarily to the Torres family, to the judge, to his daughters. I know you all know who I really am, and that I did care for George, and that I do still love George. I know you know that we had very many good days, and I take offense to the statement of being said that this is just for a moment. Right now with me here in the courtroom in front of you all, this is just for a moment. But the moments before that, in order for me to be here, is endless. It's everlasting. The scars that I have on the inside, my outside scars have healed, except for my stab wound. But this has changed me as a person to see things differently and to understand things differently and to not be weak and just try to protect yourself, and forever, regardless of the time that I may receive from today, I forever will have this experience. I forever will have George Torres with me in my heart, in my mind, my body, and my soul. As he and I used to say that we were one soul split into two bodies. This is not just for a moment. It may be for everyone in this courtroom, but when I leave, this is forever. When you all leave, that this is forever. This is forever for everyone here and those who it matters to most. I am one of those who will experience this forever. I'm sorry. Words do not define my shame, and I don't know what else it is that I can say and convey to the Torres family how this happened. The ifs and whys and how really don't matter. It happened, and I'm sorry. Words cannot describe. And I hope that everyone can forgive me, the Torres family most of all, and his daughters, because I know what he meant to them. And I don't think that anybody ever understood what he meant to me and I to him. And I ask for forgiveness.
Ms. Boone, I have just one or two questions, if you don't mind. And you can speak on it if you want or not. But this is a unique case, and one of the reasons it's so unique is that you were in jail for 4.5 years prior to your trial. And I understand that when you were brought up as a child that you did have some spirituality in your family, some church, some religion.
Always.
But I understand that you got away from that. Did you have a chance during the 4.5 years to look back at your spirituality?
Absolutely. You know, everyone supposes that this is one of the worst experiences of my life, and it's actually been one of my greatest. If I were not beaten to death, I was going to work myself to death on the outside, and I never had time to get back into my Bible and to pray and to be with the Lord. And I, being here incarcerated, have had time, of course, to get closer to God, to reacquaint myself to Him and realize what it's all about. This is all temporary. And when I say temporary, I don't mean by being set free in jail or from prison or wherever else. It means being set free and temporary, meaning that you work for something higher, you work for God, that you strive for your crown to be placed upon your head by Jesus Christ by being said, "You have done well, my good and faithful servant." I've always tried to be a good and faithful servant. I was just a servant as opposed to doing all that I can when my family were alive and I was going through everything up to this point. I've become so much more closer to the Lord, and it's made me such a better person, and I hope that I am an example going forward of the Lord's light and can draw many people to me because of it.
Any follow-up, State?
No, I assumed that was the final word.
Thank you. She can return back to council's table. Anything else from your side of the ledger, Mr. Owens?
No more witnesses, Judge, just arguments.
Okay. Anything else in rebuttal, or just proceed to argument, State?
Just proceed to argument.
Okay. All right. Once Ms. Booth's seated, you can proceed with your argument, either Mr. J or Mr. Cacciatore. You may proceed, sir.
Your Honor, I'm going to start my argument by what I anticipate Mr. Owens will bring up in his presentation regarding the plea offer in this case. That she was offered the resolution in this case of 15 years in the Department of Corrections to begin with. I think it's important, though, that the entire circumstance of that plea offer is put forward. And there's something very critical to that. It's not just 15 years in the Department of Corrections. It's 15 years in the Department of Corrections, but it's predicated on something. And the consideration that it's predicated on is the defendant coming to court and accepting responsibility for her actions. For her coming to court and saying, "I am responsible for George Torres's death, and I accept the punishment that comes with it." That consideration was never given in this case. And because that consideration was never given in this case, the offer of 15 years in no way represents what this case is worth, or what George Torres's life is worth. That is an offer predicated on a particular circumstance, a circumstance of a first-time defendant accepting responsibility and giving every benefit of the doubt in coming to court and saying that they are ready to be punished. Those conditions were never met. So then we turn to this case, and we turn to this crime, and we turn to the actions of the defendant of taking the law into her own hands and murdering George Torres. She has never shown remorse for that. She didn't show remorse for that here today. She again painted herself as the victim. She's the victim of George Torres. She recounted the litany of evil deeds and mistreatments that he perpetrated upon her. She's the victim of George Torres' family. She's the victim of the police. She's the victim of social media. It's all about Sarah Boone. Everything's about Sarah Boone, about how she is the victim. But Sarah Boone sentenced every one of George Torres' loved ones to a life sentence. just like she sentenced George Torres when he was in that suitcase. George Torres lived out his last nightmarish circumstance in that suitcase, begging to be let out for several minutes, which undercuts any argument that this was somehow unsophisticated. There was ample time and opportunity over and over for her to do something different, but she went forward with taking the law into her own hands and ensuring that George Torres was never getting out of there, while she went up to bed and went to sleep for hours on end. She can't say that she was in duress for the same reason. She was in such duress of George Torres that she goes upstairs and goes to sleep for 11 hours. Your Honor, there's been nothing from the testimony of Dr. Harper either that establishes any type of diagnosis that would give this court a basis to downward depart. Dr. Harper has put blinders on to the fact that she has been incarcerated for 58 months. 58 months with the opportunity to receive mental health treatment, and the expert witness is absolutely incurious about what any of those records or diagnosis or anything that would have been there would have said. There is no valid basis for a downward departure in this case. She deserves a life sentence. Thank you.
Mr. Owens, response?
Just credit. First off, I want to thank you for taking the time to hear our side, hear the witnesses, and review the letters on Sarah Boone's behalf. We've all been here for this trial. We've all been here for other trials. We've all got some age on us. We've all got some life experience on us. And this is a unique case. This was a unique homicide. It was a unique death. And as we all know, a lot of these cases are not black and white. They're shades of gray. And these crimes don't occur in a vacuum. That there's generally a history, especially involving a domestic couple, a history that comes into play that must be explored. And a lot of what Sarah Boone testified to here today probably happened behind closed doors. And we all know that many times we do not know what happens behind closed doors between a man and a woman in their home, unless there is some reason for the neighbors or law enforcement or somebody else to get involved. And that happened in this case. And so gradually over time, as this event occurred, there was an investigation, and it was learned that there was a history of domestic violence involving these two parties. And what we learned was that physically there was violence, and there were photographs to establish that, as were introduced in the trial. And then there was testimony from experts, not only the defense expert, Dr. Harper, that Sarah Boone was the victim, and she was a victim of intimate partner violence, but coupled with the fact that the state's expert testified on the stand at the trial that Sarah Boone was a victim
of intimate partner violence, that she suffered from this domestic or this battered spouse syndrome as the hands of George Torres. So there's two sides to it. And in a domestic violence situation like that, 95% of the women get out of that relationship. When violence starts to occur, they've either been raised a certain way, they have a certain self-esteem about themselves, where they refuse to put up with it, knowing that it's wrong, knowing that they can do better. But there is a small percentage throughout the country that, for whatever reason, mental health issues, addiction issues, whatever it is, it's complex. Financial reasons, children are involved, whatever. If you do any studying on it, there are circumstances where there is a group of women, predominantly women, it can happen to men, but majority of the time it's a woman that gets caught in this cycle of what we term as intimate partner violence. And heard the testimony about the cycle that occurs. It's over a period of time and it repeats itself, and you go through these phases. And a lot of times the victim's not a great historian at trying to articulate it. She tried to do it here today. And I think on Sarah Boone's behalf, she is a unique individual. She's got the personality that she's got. I don't know, you heard from Dr. Harper that a lot of that was formulated based on the way her mother did not bond with her, the way that her father was the way that he was, the fact that she lost several relatives at a young age, and the trauma that can result. We heard from Dr. Harper that she did suffer from post-traumatic stress as it relates to that trauma in early childhood, and then again as it relates to the events that occurred between Mr. Torres and her. So it's complicated, Judge. It's complicated. But the jury has spoken. Sarah Boone was entitled under Florida law to present that defense, and she did. That testimony was allowed to be presented. She was allowed to testify. But the jury spoke. And so here we are today with you in a position to decide what is justice for Sarah Boone. And I don't know you that much other than our time together, but from what I know you try to do the right thing. And that's what we're asking the court to do. To have some discernment, to have some understanding of the unique situation that Sarah Boone found herself in. And quite frankly, Judge, this all didn't occur behind closed doors. A lot of this was in the public eye. Mr. Torres had, I believe, 3 criminal cases before the courts of this county in which Sarah Boone was a victim. Mr. Torres was the accused. Those cases were dismissed. We know from the history of this domestic violence field that that's normal, that Sarah Boone every time either tried to bond him out or tried to get the case dismissed. At some point, somebody has to stop. Somebody has to say, wait. What's going on here? This keeps repeating. It's going to get worse. Something's going to happen. The system failed Sarah Boone. I'd ask for you to consider that. The circumstances surrounding that failure and what led us here today. I've asked the court to consider a downward departure. I believe you've gotten a copy of the score sheet.
Not since before trial. Is the score sheet stipulated to?
Yes, yes, sir.
All right, you may approach. Thank you. Yes, sir.
Judge, I was provided that here today, and I believe, I can't remember the total number of months that it involves, but divided by 12, I think it's 20 months. 20.6 is the low end of the guidelines or something about.
It's 246.0 months based on the score sheet.
I did the calculation, but I believe that the low end is 20 years, 20.6 years state prison, I believe is the low end.
20.5. Yes, sir.
And as the court knows, I believe it's on page 3, there are some aggravators that the court can consider in imposing the sentence, and then there are a list of mitigators that the court can consider in downward departing, meaning going lesser than the low end of the guidelines. And in the defendant's motion for downward departure, we mentioned, and I had Dr. Harper testify about 2 or 3 of the grounds, and the court needs to only find one to go below the guidelines. The capacity of the defendant to appreciate the criminal nature of her actions and to conform said actions to the requirements of the law were substantially impaired. Judge, I don't have to reiterate the facts and circumstances surrounding this event. You were here, you heard the testimony, you heard the circumstances surrounding what happened and how it happened. I would ask that you consider that as a mitigator. 2D, the defendant requires specialized treatment for a mental disorder that is not related to substance abuse or addiction and is amenable to treatment. I think it's fair to say here that we know that Sarah suffers from some mental health issues, objective mental health issues that have been opined by Dr. Harper and Dr. Werner. And you heard Dr. Harper testify about the post-traumatic stress disorder that she suffers from as it relates to this event, as it relates to her trauma that occurred in childhood. I think we heard from Dr. Werner. Dr. Werner testified that she suffered from the alcohol abuse disorder, as did Dr. Harper, but Dr. Werner also mentioned that she was not for sure about the anxiety disorder, whether it occurred prior to or because she was in the jail for the 4.5 years. However, she does require specialized treatment for the mental disorder, and she is amenable for treatment. And then third, the defendant acted under extreme duress, I think based on Sarah Boone's mindset as she testified to her today, and then you heard from the experts at the trial that when you get that anxious about what happens, Sarah testified about they would have good days where there would be no drinking or very little drinking, and then there would be other days where there was heavy drinking, and generally when George Torres got highly intoxicated is when potentially things could get violent, and that she was constantly anxious about each day that she was with him. She loved him, obviously being in a cycle like that where you love someone but can't leave them. For whatever reason, George Torres couldn't leave Sarah Boone, and Sarah Boone couldn't leave George Torres, and it was a vicious cycle. But we believe that she qualifies under that it was under extreme duress at the time of this event. And lastly, the defense was committed in an unsophisticated manner, which was an isolated incident. Now, isolated, we know, Judge, that she had one prior event in which both of them were arrested. You heard her testimony that it was during an event. They ended up downstairs next to the washer and dryer, and that she was on the bottom, and she had used her hands to try to get him off, and she had tried to choke him, and there were some marks on him. And she was arrested for felony domestic violence battery, as well as he was arrested. I think a few days later, both of those charges were dismissed against either party. But she has no criminal conviction record. She has never been convicted of a crime other than that event. Now, I think that can be distinguished. So we believe that it was an unsophisticated manner. Obviously, the uniqueness of this event is unsophisticated. Anybody that would calculate that they were going to murder somebody by putting them in a suitcase and let them spend the night and the next morning, not try to dispose of the body, not try to put the suitcase in a car and go dump the body, not try to dispose of the bat, do something. She did nothing. No attempts to tamper with evidence. No attempts after the fact to uncover any conduct whatsoever. No attempts to delete the videos from her phone. Here's my phone, voluntarily given that information. I think that goes to the unsophisticated manner and unintentional death that occurred. I remember the first time I saw the suitcase video. And I know people have differing opinions. Tony Henderson, my colleague, had a different opinion when he saw it. But I remember the first time I saw the video, and I heard what she was saying to him. When he was saying, "Hey, Sarah, let me out. I can't breathe," or words to that effect. And the way that she was talking to him, and the statements that she gave to him, in my mind, what has he done to her? What has he done to her? Any loved one you see in a situation like that is going to run and let him out. So my thought was, obviously, they were both drinking. But what has he done to her? And I think it's telling about what she'd endured. So it's not a clear-cut case, Judge. It's not black and white. There is some gray. And it's up to you to decide what's appropriate based on the court's, based on the jury's decision. But I would ask you to temper whatever justice that you think is appropriate with some mercy. And consider the fact that the state was willing to offer 15 years on a manslaughter as a lesser included offense based on the facts and circumstances that they were aware of prior to this trial. Thank you.
Thank you. Any rebuttal by the state?
No.
Okay. The court has had the opportunity to review the evidence and testimony that was presented at trial. The victim impact statements presented here today, the statements of character witnesses, both orally and in writing, Dr. Harper's report and testimony, the defendant's testimony, pre-sentencing investigation, the arguments of the state and the arguments of the defense. Court pronounces sentence as follows. Ms. Boone, court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily. There are also court costs and costs of prosecution, which Madam Clerk will give you the totals of momentarily. Due to the court levying a life sentence, the court is inclined to liquidate those to a civil judgment unless I hear opposition from the state.
No opposition, Your Honor.
All right. Madam Clerk, if you could please give us the credit time served and the court costs, please.
4 years, 9 months, and 8 days, and the court costs are $418, a state prosecution fee of $100, a dirt fee of $50, and a PD. Oh, excuse me, you're not supervised.
I'm right.
So the total would come up to $618.
All right, ma'am, the court costs and costs of prosecution are $618. Those will be liquidated to a civil judgment. You will be given credit time served of 4 years, 9 months, and 8 days. You will have 30 days from today to appeal the judgment and sentence in writing. If you cannot afford an attorney, one will be provided to you. I'm going to have the courtroom deputy provide you the paperwork. Because you've been incarcerated for the last 58 some odd months, the court is going to declare that you are indigent in this matter. I cannot appoint the public defender to represent you as they are conflicted out. Similarly, I cannot appoint the regional conflict counsel to represent you for the same reasons. The clerk will appoint an attorney from the conflict wheel who specializes in appellate litigation. And again, you'll have 30 days from today to appeal that judgment and sentence in writing. Do you have any questions for me? You will now be remanded into the custody of the Orange County Jail to transfer you to the Department of Corrections, and I wish you the best of luck. State, anything further?
No, Your Honor.
Defense, anything further?
No, sir.
All right. Thank you all very much. Court's off the record.
Thank you. Thank you. I'll mail it to you. I'll mail it to you.
You might be right. It's not that one. It's not the same one.
She's on her way.
Okay. Can you go give me a heads up when they get her here?
Yeah, I got you.
I gotta go down and see her real quick.
All right.
Start.
I just didn't know. Sometimes they do it and also for after doing the job right now. Yes. Do you mind scooping?
They're going to give me a signed document before she leaves. Oh, is that it? Can I see if she... Is this it? Can I record?
No. No. That's the other one.
It's the wrong one. Just hold on. All you got to do is sign. I'll help you do it.
Okay, so that concludes this trial. And we will... That concludes this trial, and this was a cool replay. I remember when it happened, it was pretty crazy. It was pretty nice to revisit it again. Likely will be live later. There's going to be a trial soon with the defendant Lindsay. Later I'll probably do like a preview about what that trial is going to be about. And and now this one will be ending. I mean, it might be starting tomorrow, but I'm not completely certain. Glad that y'all enjoyed this one. Okay. So now this one will be ending, and likely will come back later. So thank you all for coming.